that our aim is to achieve compliance through credible enforcement activity and thus contribute to prevention and harm aversion, and that we're trying to ensure that regulators throughout Australia are working better together. Part of that, for those of you who are interested in this sort of stuff, is that the Work Health and Safety Act will allow inspectors in Victoria, on the authority of WorkCover New South Wales, to exercise the powers of an inspector in New South Wales, which we think is a great thing. In fact, the Victorian Government's submission to Barry's review panel was very strong on this point. And I must say I'm personally pleased that we're getting to that point, because it's common sense, isn't it, really? Again, another exercise in common sense. If we're all working to the same laws, there'll be 9 different acts, but if we're all working to the same laws and the same enforcement and compliance regime, why the heck wouldn't you allow inspectors in one state, on the authority of a regulator in another, to exercise powers in that state as well? It will remove over time what would otherwise be called conflict, I suppose, at the borders, such as in Albury-Wodonga and other places. It will remove confusion for duty holders, people like yourselves working in those border towns, and again it will over time produce economies in our approach and allow us to do things like, and we will be doing this, produce a national training scheme for inspectors, which all of them will over time be undertaking or able to undertake. They're the likely features of a national compliance and enforcement policy. I do direct your attention to point 3, encouraging duty holders to comply through guidance, education, advice and capability building, while ensuring that there are fair and swift consequences for those who don't do the right thing. But that said, as a modern regulator, we are talking about providing as many tools as we can to assist you to get from point A to point B without having a prosecution in the middle, which is only appropriate. They're some of the likely features of the National Compliance and Enforcement Policy in terms of the bases on which we proceed with a prosecution: reasonable prospect of conviction, prima facie case to answer, etc., etc. They're the criteria that we will apply in determining when to enforce. I direct your attention to the last dot point in particular, the compliance history and attitude of the duty holder. Again, let's steer our way through that euphemism and just say, if you're a repeat offender who really will not be told, you're more likely to be in trouble in terms of a decision we may make to undertake strong enforcement action in the form of a prosecution than if you're that officer we were referring to before, who, despite their best efforts, couldn't convince their organisation to spend $10,000 to improve health and safety. That's the suite of prosecution options that we have, or enforcement options that we have under the work health and safety laws. I think there's a couple of others in there, including adverse publicity orders. It's again common sense that organisations who value their reputation will not take kindly to being compelled at their own cost to pay for publicity in national media, advertising the fact that they have been prosecuted for an offence under the Act. For what it's worth, one of the last things I saw before I left this morning was that Victoria's first adverse publicity order has actually been made very recently, last week in fact, by a court. So these prosecutorial options are ones which we essentially already have in Victoria. Just in conclusion, if you essentially are at least familiar with our prosecutions, our enforcement and compliance regime in Victoria, there isn't a lot there, I'm pleased to say, which is going to be new for you, and that which is new is not going to be that remarkable, except for a couple of things which Barry's going to talk about now.
Good. Firstly, on this slide, the disclaimer. This was one of the recommendations the ministers did not accept. They instead, funnily enough, relied on the advice of the regulators to give the regulators what I'd call fairly extreme powers. At the moment in Victoria, you do not have to answer questions other than questions relating to documents that are asked for. You do not have to sign a statement. You do not have to attend for a recorded interview. You have the privilege against self-incrimination. That will all change from 1 January 2012 when the new laws, and we recommended something quite different, but when the new laws will remove the right to silence, you will have to answer questions. The privilege against self-incrimination will not stop you having to answer the questions. You will have to answer even though it might incriminate you. If you assert that the question may tend to incriminate you and the privilege would apply, then it can't be used against you in court. Your answer can't be used against you. It's called a use immunity. But you have to assert that for the particular question. If you do not, you are taken to have answered it voluntarily. And we know this because this applies in New South Wales at the moment. You'll be taken to have answered it voluntarily and your answer can be used against you in court. Legal professional privilege is enshrined in the Act as it is in Victoria now. Now, we tried to make this Act better and, frankly, not needing lawyers. Making it simpler, making it work better. But this is one thing where the ministers have given us a free pass. If anything significant goes on in your workplace and it is investigated by WorkSafe, get a lawyer. You will need one. You will need it so that the rights that you have available to you are properly and effectively followed through. Legal professional privilege protects David and his good people from getting access to things which we do for you, which allows for warts and all investigations, and the information isn't hidden with the fear that it will have to be handed over. Now, safety should never, ever, ever come second to the law. The law is far more important than the safety is far more important than the law. Safety is far more important than law. But any lawyer worth their salt who understands that and understands this area will in fact make sure that safety critical information does get out in a timely fashion, and it isn't held back for legal purposes, but it has to be done carefully. That's all I really need to say about that. Just simply that a new era will dawn. You will have to answer the questions. I think we've talked about all this other stuff, union right of entry and so forth, so David can take you through the penalties.
Yeah, I'm going to actually race here. I'm told I've got 10 minutes. Can I just say on that last point, I understand Barry's concerns and indeed your concerns about the what we call the abrogation of the privilege against self-incrimination. For the record, Victoria was strenuously opposed to the insertion of that provision into the Work Health and Safety Act. WorkSafe Victoria, as a prosecutor, is very comfortable with the privilege against self-incrimination that we have under the Victorian Act, and being able to work with it and to maintain prosecutions where we should. But unfortunately, we live in a democracy, and new federalism means we have the same voting power as the Northern Territory and the ACT and other jurisdictions, and that means that that was one area where we were unsuccessful. But in any event, enough of my defensiveness. Let's just talk now about the penalties. We weren't happy about that result, I can tell you. There are 3 levels of penalties, categories 1, 2 and 3. The maximum penalty is $3 million for a corporation for what is essentially the offence of reckless conduct. I sincerely hope no one in this room or your organisation is ever in court on that offence, because it will have meant that someone's been killed and you've been really, really reckless. You know, as I said at the outset, we'd much rather not have to run those sort of cases. We suspect strongly that the vast majority of our prosecutions and enforcement activity will be in categories 2 and 3. You'll note that the maximum penalty for category 2 is 1.5 mil. That's a few $100K more than what the maximum tariff is in Victoria for offences. So I suppose, again, at the risk of stretching the, I'm not stretching the truth, just basically leaping to make a call on it. There isn't a great deal of difference in a practical sense between the penalties recommended by the panel and what we currently have in Victoria, except for that top tier penalty of $3 million plus 5 years in prison for individuals who by their reckless conduct caused the death of another. We're very comfortable with that. I now want to take you very briefly through the... there are several elements to these regulations which will be new for Victoria, however. Can I direct you to, in particular, electrical safety? There'll be an electrical safety reg in the model regs. There'll be a workplace management reg in the model regs. Given the nature of the sector that you're in, can I direct your attention to the remote and isolated work provisions, which are likely to be the subject of regulation in Victoria, indeed the whole of Australia. I say likely because it has to go through a process of public comment first. Essentially, there's a number of fatigue and long-haul transport. Victoria's position on what remains a proposal is that there should not be a fatigue and long-haul transport reg, but there may be.